Hello, and welcome to another installment of Bracewell's Environmental Essentials for In-House Counsel. I'm Brittany Pemberton, a partner in Bracewell's Environment Lands and Resources Group here in the Washington, D.C. office, and I'm joined today by my D.C. colleague, Jeff Holmstead. We're talking this morning about EPA's 2009 Endangerment Finding and what the Trump administration may be doing next. So, Jeff, I thought maybe a good place to start would be for you to remind our listeners really what the endangerment finding is about. Where does EPA's statutory authority come for this? What was in the finding and what led up to it?
Sure. I'm delighted to have the chance to talk about this. And I want to go back maybe a little earlier than that people typically think of. And this goes back to my time at EPA when I was at the EPA Air Office. When we took office, when President George W. Bush was elected, the Clinton administration had released a document arguing in a memo signed by their general counsel saying that EPA did in fact have authority to regulate CO2 emissions under the Clean Air Act, and they had declined to exercise that authority. At the same time, there was a petition pending from a group of environmental groups, a rulemaking petition specifically asking them to set CO2 emission standards for vehicles. That petition had been pending during perhaps 5 years of the Clinton administration, and they had declined to act on it. But they had taken the position that they did have authority. So when we came into office, we believed, and I continue to believe, that Congress never intended CO2 to be regulated under the Clean Air Act. It just didn't make any sense with the various regulatory provisions. And so we decided that we would go ahead and reject that rulemaking petition. And in doing that, we specifically took the position that CO2 was not a pollutant that could be regulated under the Clean Air Act. And we actually reached that decision based on what would now be called the major questions doctrine. And I remember working on the document, and we actually specifically cited to Brown v. Williamson, which was an important case that the Supreme Court also cited to in the West Virginia decision where they adopted the major questions doctrine. And we sort of went through the history of the Clean Air Act, and we argued that would be regulating CO2 under the Clean Air Act would be a decision of enormous economic and political consequences, quoting the language from Brown v. Williamson, and said that we didn't think that Congress had intended that. They certainly had not made that clear, and therefore we didn't believe that EPA had authority to regulate. That decision, the rejection of that rulemaking petition, went to the D.C. Circuit, which upheld it. And then the decision by the D.C. Circuit was then appealed to the Supreme Court in a case that is now well known as Massachusetts versus EPA. And in Massachusetts versus EPA, by a vote of 5-4, the Supreme Court held that, in fact, CO2 emissions, they didn't really address Brown v. Williamson or what congressional content had been. But they quoted the language of the act and just said under the language, greenhouse gases and CO2 meet the definition of an air pollutant. And since they meet the definition of an air pollutant, it now is incumbent upon EPA to determine whether greenhouse gases are reasonably anticipated to endanger public health or welfare under the relevant provisions of the Act. So the Supreme Court essentially said, and in fact said very clearly, that EPA now has to make a decision as to whether greenhouse gases are reasonably anticipated to endanger public health or welfare. After I left the Bush administration, there was a discussion as to whether they should make or decline to make that decision. They did not do it one way or another. And then when the Obama administration took office in 2009, they went through a notice and comment rulemaking, what they determined to be a legislative rule. And they specifically found, based on a pretty robust body of scientific evidence, that emissions of greenhouse gases are reasonably anticipated to endanger public health or welfare. So having gotten to this point in history, these are the provisions of the Clean Air Act that are relevant to the endangerment finding. And in fact, back in 2009, the Obama administration was focused entirely on Section 202A1, because the question was whether they could regulate greenhouse gas emissions from motor vehicles. And under Section 202A1 of the Clean Air Act, it says that EPA is required, shall prescribe standards for any air pollutant from new motor vehicle engines, which in his judgment or her judgment cause or contribute to air pollution which may reasonably be anticipated to endanger public health or welfare. When the Supreme Court pointed to the endangerment finding, they characterized this as purely a scientific finding. And that is the way that the Obama administration addressed the issue. And in 2009, what is now called the endangerment finding, they specifically made a positive finding and based on that finding, proceeded to regulate greenhouse gas emissions from motor vehicles. So the first regulation that came out was in fact for mobile sources. Later on, when they did the Clean Power Plan, they pointed to that endangerment finding, but also made it under Section 111B1A. But the language is essentially the same, that EPA is required to regulate if the administrator finds in his or her judgment that it causes or contributes significantly to air pollution, which may reasonably be anticipated to endanger public health or welfare.
Yeah, so with that really interesting background in mind, I think everybody probably knows that, on day one of this administration, President Trump signed an executive order about unleashing American energy. And one of the things that was in that order was direction to EPA to work with other agencies, basically to consider whether something should be done in terms of reconsideration or rollback or something like that on the endangerment finding. And since that time, we know that the administrator had 30 days and did make some kind of recommendation to the White House at sometime in February. And then much more recently, on March 12th, there was sort of a bonanza of regulatory rollback plans announced. And among those 31 different actions that EPA announced was a reconsideration of the endangerment finding. EPA published like a press release for that announcement, and they also put together a fact sheet that I think maybe gives us a sense of what it is the administration may be thinking or what approach they may take to the endangerment finding. Do you want to walk through some of what we can glean from that?
Yeah, I did want to pull out some of the specific language from that press release. And I think there's sort of three paragraphs that are particularly important. And the Trump administration has made it clear that one of the things that they would like to do is, I think they say, drive a stake through the heart of climate change regulation under the Clean Air Act, which suggests that they are not only planning to reconsider, but probably planning to revoke the endangerment finding. And their press release indicates, I think, how they at least currently plan to go about that. And I've put the language up here. So this is from the EPA press release, and they criticized the 2009 endangerment finding because the agency did not consider any aspect of the regulations that would flow from it. EPA's view then was that the finding itself did not impose any costs and that EPA could not consider future costs when making the finding. There's a couple of similar statements in that press release. There's a quote from the fellow who is scheduled to be or has nominated to be the head of OIRA, the part of OMB that reviews regulations, where Jeff Clark says that since 2009, he's consistently argued that the endangerment finding required a consideration of downstream costs imposed on both mobile sources like cars and stationary sources like factories. The indication being, I think, that they are planning to reconsider the endangerment finding and determine essentially whether it's justified based on the cost that will be imposed, what they call the downstream costs. And then they also, in that same press release, mentioned some other factors that they plan to take into account. And I won't read the whole thing here, but they do say that since the endangerment finding, the world has seen major developments in innovative technologies, in science and economics, and in mitigation. I think they're likely to run into problems under the Loper-Bright decision, because if you if you look at the language of the statute and going back to the language of the endangerment, the question is whether emissions cause or contribute to air pollution which may reasonably be anticipated to endanger public health or welfare. There was a litigation over this finding. In fact, it's been litigated in several different ways. But ultimately, in the first case that went to the D.C. Circuit, the industry petitioners essentially made the argument that it appears the Trump administration wants to make now. And that is, they argued that EPA improperly interpreted the Clean Air Act as restricting the endangerment finding to a science-based judgment devoid of considerations of policy concerns and regulatory consequences. But what the court held was that those arguments were foreclosed by the language of the statute and the Supreme Court's decision in Massachusetts versus EPA. So it appears, at least based on the press release and the statements that we've seen from the administration, that they are trying to revisit some of the arguments that were made not only in the original DC Circuit litigation, but in subsequent litigation that have been rejected by the courts. And the other problem they have is that same kind of endangerment language appears throughout the Clean Air Act. And in every case, it has always been viewed as purely a scientific judgment. And so trying to take into consideration some of these other factors, I think they have a real uphill battle, at least in making sure they can reverse the endangerment finding in a way that will actually stand up in court.
What do you think about the press release mentioning major developments in mitigation? Is that something that's been considered in endangerment findings in other contexts? And is that a way that, might help with some of the problems that you're talking about?
So I don't see how it can. And then I guess but even when it comes just to costs, in the press release, they do mention that the mobile source regulations that EPA has issued under prior administrations are expected to cost in more than $1 trillion, but there's no reason they have to. So it's very hard, I think, to figure out how you would estimate the costs that come from the endangerment finding, because all that does is authorize EPA to regulate. It doesn't say anything about how stringent those regulations should be. And in issuing any regulations that would be done on greenhouse gases, they would have to take the cost into consideration. It seems like if Massachusetts versus EPA were to go to this to the current Supreme Court under the major questions doctrine, you would expect them to say that the regulation of CO2 under the Clean Air Act is a question of major political and economic significance, and Congress would have to speak clearly to the question that EPA had that authority. But it's not, and sometimes I wonder if maybe when they're talking about reversing the endangerment finding, they're hoping to find another way to sort of relitigate Massachusetts versus EPA. And to me, that seems like a potentially more fruitful way than trying to undo the endangerment finding based on the costs or the consequences of the mitigation that it could somehow require.
That certainly strikes me as the most durable way to do this, because I think one of the, sort of practical concerns about reconsidering the endangerment finding at this point in time is that it is hard to imagine, shy of taking down Massachusetts v. EPA, that this EPA can figure out a way to do this, that, the next administration that comes along that has a different set of policy prerogatives isn't just going to issue a new endangerment finding. So obviously undercutting the fact that greenhouse gas emissions are air pollutants under the Clean Air Act would help in that regard. But, maybe that's a good segue to one of the other topics that we thought we would cover today, which is really, what might be the ramifications of all of this. I think there are, sort of practical concerns, but also, maybe one potential major legal concern, practically speaking. it's for the reasons that I just mentioned with the durability, it strikes me as a heavy lift and a resource intensive effort by this administration. And we know that they've got, obviously other statutory obligations. They've got deadlines that they have to meet, from judicial consent decrees and other deadlines that are out there. And plus they've announced, 30 other efforts to do regulatory rollbacks, some of which include multiple other rules. They're not just a single rule in each one of those announcements. And it just strikes me as something that is going to take a lot of resources of the agency to work on this. And it's not clear that that's really going to pay off. I mean, I think if they were able to find a way to tee this up, to go back to the Supreme Court on, that threshold question of what's an air pollutant, it would be certainly interesting to watch unfold. I'm not, a huge Supreme Court watcher. I dabble in that. And it sort of strikes me that it's unclear whether there would be enough votes to really accomplish that. What do you think?
Well, as I said before, I think if this question were to go up for the first time now, under the major question doctrine, they would likely find that CO2 isn't a pollutant under the Clean Air Act because Congress clearly never clearly made that intention known. But the question is now whether they would be willing to overturn that case. And, historically, they've been very skeptical about overturning any statutory interpretation because the view has been that if they make a mistake in interpreting a statute, then that's up to Congress to fix. Certainly, we've seen that on constitutional questions. So I guess I agree with you that this seems like a real uphill climb. They would either have to get the court to revisit that, or they would have to persuade the courts that the endangerment finding is not purely a scientific matter, but also would take into account these other consequences that they've talked about in their press release. I don't know. I mean, you've certainly followed some of the scientific issues. Do you think there's a plausible case they could make for saying that greenhouse gases don't endanger public health or welfare?
I mean, I think that there are ways that they could do less than a full repeal, perhaps, that would get at that, and your distinction between the mobile source authority for the endangerment finding and the stationary source one, I think becomes important in this regard because of that significantly contributes modifier. If they're able to slice this in a way to say that there are only certain industries that significantly contribute in the US, or that, despite everything that has been put in the record over the years about the science of the impacts of climate change and carbon emissions, that the US as a whole does not significantly contribute to global greenhouse gas emissions, maybe that's a way to go about it. And that would be, again, like an interesting case for the Supreme Court, because it would go all the way up for sure.
Yeah, that does seem more promising to me. Not to sort of take on the science of climate change altogether, but make the point that even if you're looking at total U.S. greenhouse gas emissions, they're a relatively small share, and that share is declining as our emissions decrease and as other emissions from other nations increase. So I do think that at least when it comes to stationary sources, that may be more promising. Although, as I recall, the Trump administration tried to do something similar at the very end of the administration, and part of that had to do with the methane regulations. Wasn't there a CRA petition for?
Yeah, a Congressional Review Act resolution of disapproval was actually enacted on the Trump administration's efforts to roll back the regulation of methane from the oil and gas industry. And that, is sort of another interesting legal wrinkle, I think, in this whole debate. When you repeal a regulation via the Congressional Review Act, the implication is that it's as if the regulation has never been on the books, but it also bars the agency from doing some regulation down the road that's substantially similar, and there are potential consequences, I think, from that rollback in terms of limiting the Trump administration's flexibility with some of the rationale that they might be inclined to use to do some of the things that we were just talking about in terms of, not a full repeal, perhaps. But I think it is worth noting that, in addition to sort of practical consequences and a lot of legal issues here that we're obviously only just touching on in terms of the amount of time that we have, that the one big legal drawback that I see to potentially repealing or revoking the entire endangerment finding is this issue of using the Clean Air Act and regulation under it of greenhouse gases as a defense, sort of in the tort arena. Um, you know, there have been a number of lawsuits attempted over the years. You'll see on the slide that really the seminal case, American Electric Power, the Supreme Court held in this case that really there's no cause of action for climate nuisance because EPA is occupying the field. That ability that EPA has, because Massachusetts v. EPA found greenhouse gas emissions, or carbon dioxide more specifically, I guess, to be an air pollutant under the Clean Air Act. And then EPA has the authority to regulate those emissions, is what blocks efforts to hold emitters of greenhouse gases liable for those emissions and for the consequences of them.
Right. And I think in the AEP case, that specifically dealt with federal common law tort claims. But I think that's also an argument that has been made in challenging the various state climate change Superfund laws. Is that not right?
Yeah, that's right. I was just going to mention that, which is, if you've been following that in the news, there's maybe something like a dozen states that have proposed some legislation, and 2 states, Vermont and New York, that have actually enacted into law that, the gist of it is that these states come up with an estimate of all of the climate damages in the state. And then they look for folks who have been involved in fossil fuel exploration, production, development, refining over the years over a certain threshold, and then are going to charge a fee essentially to recoup their share of the damages within the state. And for Vermont and New York, where those laws are finalized or they're on the books, there have been lawsuits filed already. And, even though there are some other defenses out there that the states that are challenging those laws have brought to bear or hoping they'll be able to bring to bear, they have really made this notion of the Clean Air Act as preemption their lead argument.
And I think we saw an executive order just last week where the president directed the Department of Justice essentially to look for ways to challenge not only those laws, but some of the litigation that is being brought either, under various theories. And so I think your point is that if that's part of what they're trying to do, they've maybe eliminated, or they may be planning to eliminate what the leading argument has been for preempting those cases. The fact that EPA has authority to regulate CO2 emissions under the Clean Air Act essentially preempts state efforts.
Yeah, that's right. And that EO is quite a bit broader, not just on the climate superfund legislation, but it also mentions, cap and trade in California and things like that, all under the auspices of curbing, what the Trump administration sees as state overreach. But I do think, the connection between all of this is pretty interesting, because if the motivation were to get to the Supreme Court and to undermine Massachusetts v. EPA, it might actually make this problem a little bit worse, I think, because, maybe there's sort of an argument in between where we are right now, which is EPA has the authority and it's been regulating, and therefore there's federal common law preemption, or there's preemption of these legislation. If you were to undermine or overturn Massachusetts v. EPA, where it's not even clear anymore that EPA has the authority for these regulations, I think that really takes the wind out of people's sails of trying to use this one. Like I said, though, there are some other defenses out there that folks are bringing against these laws, mostly different flavors of constitutional arguments, that those would not be affected at all by everything that's happening with the endangerment finding potentially.
Yeah, there are obviously many other issues here, and we may be having a similar webinar once we see how they actually proceed, when they actually propose, presumably, to overturn the finding. But in the meantime, Brittany, I know you had looked at a lot of sort of a number of key procedural issues where we really have a lot of questions about what their next steps will be.
Yeah, that's right. I think there are just a number of open questions. The first of which is really, does the endangerment finding or proposal to revoke it need to go through public notice and comment, or maybe it's not a proposal, maybe it's just a final action? And if so, is there some way for EPA to do this rather quickly, knowing that one of the practical points behind taking a second look at this is to provide some regulatory relief to sectors of the economy whose emissions are regulated? I think it's really not quite clear whether public notice and comment is required. Jeff mentioned at the beginning that in 2009, the Obama administration treated this as if it were a legislative rule that would require notice and comment. I think that really just opens up the question can the Trump administration take a different view on that aspect of this? And if so, how well would that hold up in court? If they decide to go through notice and comment, would they try to use some mechanism like perhaps an interim final rule that allows them to skip some steps in the process and basically develop a rule that gets published in the Federal Register and that they would comment on, but it would be effective very, very quickly, as opposed to having to go through all of the steps of taking comment, developing a final rule, responding to comments and all of that. The ability to skip a lot of those steps is really contingent on good cause. And I think it's an open question as to how they would defend, there being good cause here. Maybe they could argue something like, this is an immediate action that's necessary to reduce imminent harm to people or property. And I think we kind of think of that in the environmental sense as being, environmental catastrophe, but I think they could take it, from an economic perspective, perhaps.
But the other question, there certainly seems to be some thinking out there that if they revoke the endangerment finding, then that basically eliminates the need for them to go rule by rule. That somehow, if they were to just reverse the endangerment finding, that would eliminate the vehicle rules and the methane rules and the power plant rules. But I'm not sure that's right.
Yeah, I don't think we know. And some of it may be, planning for the inevitable judicial review that comes, even though you'll see we've noted on the slide, is it subject to judicial review? Jeff mentioned the 2009 finding was litigated, but again, the Obama administration just sort of assumed that it was a rule. So nobody questioned whether it was subject to judicial review. Regardless of how they do this, they'll have trouble getting through the DC circuit unscathed. And perhaps there's some reason to take precaution and proceed sort of through normal course and take all of the right steps in order to keep that from being an issue that comes up in the DC circuit. But we just don't know. And it'll be interesting to see exactly where they come out on some of these issues.
Well, stay tuned. We'll presumably be knowing more relatively soon, because this seems to be a pretty high priority issue for the administration. And the question is, really, what will their theory be for revoking or reversing the endangerment finding? And we have some hints from their press release and other public statements, but when they actually put together essentially a regulatory package, we'll know much more.
So stay tuned, folks. Thanks for tuning in. As always, you know how to reach us if we can be of any help on this or any other air or climate related matter. Thanks.